Well, hello, everybody. As you start to flow in, welcome very much to this webinar, Tripping Over Dripa. I'll be your host, Andrea Palferman with Raven. And just so we know that you're there and know where you're calling in from, please say hi in the chat. Just let us know whose territory you're on and maybe say a couple words about why you've come. See, there's people starting to flow in. We've got 18 and 20, and so very, very nice. We did reschedule this from an earlier date, so we're really pleased that you can come. We're really, really pleased that folks who are actually at the hearings today and last week and the week before have managed to join us as well. So as you come in and as you're new, please say hello in the chat. And as I said, my name is Andrea Palferman. I'm the Director of Communication with Raven. So yeah, as we start, we'll just do some introductions here. First off, I'd really like to be thanking representatives of Gitxaala Nation. Unfortunately, Matthew Hill was unable to attend due to a death in the community. So we're really grateful that James Herbert kindly stepped in at the last minute. And of course, very warm welcome to Jessica Clogg from West Coast Environmental Law. And thank you so much for being here tonight as our guests. I also want to introduce Levin Chamberlain, who is Raven's Amazing Grants and Campaigns Coordinator. So Levin will be taking care of tech tonight as I'm in Northern Africa and my internet is, we'll see. Also very glad that Conrad Young is here, our fundraising campaigns director. So yeah, welcome. Beginning by acknowledging the territories we're all calling in from. I'm on the ancestral lands of the Berber peoples in transit back to the territories of the Halkomelem and Senchossan speaking peoples, also known as Salt Spring Island, BC. So let's begin by introducing James Herbert, who is a senior advisor with Gitxaala Nation, who's worked for the nation's elected and hereditary leadership for the past 6 years. In his role, and James, please take it from here once we've finished this introduction. You can tell us a little bit more about what you do with the nation, but James has been directly involved in the push to manage and address the direct and cumulative impacts of development pressures in the nation's territory to ensure that the laws and management principles of Gitxaala are upheld. Also with us tonight is Jessica Clogg, who is Executive Director and Senior Counsel of West Coast Environmental Law, where she served as an environmental and Indigenous rights lawyer for the past 2 decades. She's part of the legal team who are representing Gitxaala in their mineral tenures case. And Conrad Young, who was born and raised in Massachusetts, please, Conrad, you'll have to step in and help with that pronunciation. Conrad studied business administration, marketing, and finance before joining the joint Indigenous and Common Law degree program at UVic, and now Raven. He's a former counselor with Armidskin Cree Nation and is an heir to the legacy of Treaty 6. So let's get into it, folks. We have an incredible group of people here ready to trip over Dripa and pick apart and put together what this legislation means for Indigenous peoples and all of us here in British Columbia. So as we have our conversation, we invite you to ask your own questions in the chat as the discussion unfolds. But tonight, the spotlight is really shining on the centerpiece of Gitxaala's legal challenge, which is BC's new Declaration on the Rights of Indigenous Peoples Act, and how the lofty goals of UNDRIP are being translated into on-the-ground action, or as the case may be, inaction. So I'd like to start with you, James, as you are working so closely every day with Gitxaala Nation. Wondering if you could talk a bit more about your role with the nation to begin with.
Yeah, thank you, Andrew. And thank you for having me here. And I'll start by saying that I spoke to Hiwaas this afternoon, and he sends his regrets, and he's asked me to share his feelings of support and the the sense of holding up that he's felt in the last couple of weeks, because it's been a long couple of weeks, and he's felt really shored up and buoyed by the kind of outreach of support that he's heard from organizations all over, and including Raven specifically. So he wanted me to pass those words along. And then I'll like you mentioned, I've worked for the nation for 8 years now. And I'm what we call a senior advisor, which that role is essentially taking on kind of very key and specific projects. And this Mineral Tenure Act legal challenge has been one of them. And it fits in very much into kind of the process and the strategic nature of both my role and the direction I get from leadership. And so I don't know if you want me to go into it more, if you've got a follow-up.
Well, yeah, I mean, specifically, we keep hearing about the wonderful research that the community themselves have conducted to gather evidence in this case. And I think it's fascinating that there's someone who's been so close to that process. And wondering if you could describe some of the cultural knowledge and Indigenous legal processes that were brought forward in this case.
Yeah, most definitely. I mean, on a personal note, it's been, if not the best work, definitely some of the best work I've had the honor of being able to work with. It's been a amazing process for me to be able to sit down and learn more and more in depth about how to translate the kind of knowledge that Gitxaala has. And that is kind of one of the opportunities that this case brought forward, was to demonstrate essentially to the Crown the kind of knowledge and authority that Gitxaala's always had. And so I think that's one of the benefits of this, is the nation's own governance, its laws, its Adao, its Ayao, and its Guglians. These are the three kind of overarching legal principles that make up Gitxaala law, have always existed, and they've been relatively ignored by Western settler folks who don't want to take the time to learn. And so the ability to dive into this case and put that kind of governance front and center has been a huge part of the benefit of the work we've done. I think it was so important in our ability to kind of bring this case forward, in, like I say, in kind of translating that knowledge from the deep understanding that's held by our Samlaget. Samlaget is the Semitic word for hereditary chief, does not do it justice, but is the leadership that someone like Hiwaas has imbued in them from generations of knowledge. And to be able to kind of like translate that knowledge in a way that shines a light on like not only the power and the responsibilities of upholding that law, but kind of the injustices that are done to the nation by ignoring those laws. I think that's been, for me, I was wrapping my head around this last 3 years of work in the last month. That's been a big takeaway for me, is the benefit of that, putting the work into translate.
Well, of course, it's so incredibly important that it's becoming part of the common law system as well. It's advancing the law in such an important way in that regard as well. Well, thanks, James. We'll circle back to some of that in a moment. This next question is a bit of a zoom out. That was a zoom in to really what Gitxaala's particular concerns are in this challenge. Let's look at Dripa kind of from a wider angle for a moment. And this one's for you, Conrad. So, one of Raven's board members, Ron Lehman, who's a former chief of the Beaver Lake Cree Nation, has let us know that, the crafting of UNDRIP itself at the UN level was an arduous process. And the declaration came about through grassroots political organizing and collaboration, a phenomenal collaboration at an international level between Indigenous peoples. So, Conrad, of all the declarations and recommendations that come out of the United Nations, and I ask this as like someone who isn't up close to that process, why has UNDRIP become this kind of gold standard, and why is BC adopting this?
Yeah, thank you. Good evening. Thanks for that question from Ron. It's a great question surrounding tonight's theme. I think there's a couple ways to look at that question. I guess what comes to mind is the ability to kind of critique, I guess, what the gold standard means and where does it come from. When I think about it, I take on the ideas of looking at UNDRIP as an international instrument and also as a domesticated instrument by Canada under Bill C-262, which was introduced by Romeo Saganash in December 5th, I believe, in 2017. So when we look at it at an international level, I think the gold standard that it sets for the global governing bodies is the idea or the aspiration or the concept surrounding free, prior, and informed consent. And then looking at the way Canada has domesticated it under Bill C-262, and then also then further domesticated by the province of British Columbia as the Dripa Act. And so I think what it does is it lends to the, I guess, tool chest in harmonizing the different intersections of jurisdiction. So in this case, you heard earlier James talking about the traditional concepts of the people of Gitxaala and their governing systems over their lands, rights, and titles. And then looking at the Canadian common law interpretation of free, prior, and informed consent. And then the intersectionality of the current, I guess, what would be viewed as an Indigenous regime under Section 35 as Aboriginal rights. And so I think the gold standard is the opportunity to harmonize these different kind of legal orders as they intersect. As the mission, I believe, in the international instrument was to kind of limit or create a new idea of collaboration on unilateral decision-making, especially when it came to lands, rights, and titles of Indigenous peoples. So when we look at it as a gold standard for BC, garnering the free, prior, and informed consent of the Gitxaala peoples prior to any, I guess, infringements of their rights and titles is absolutely the hope of what you know, we're hoping the common law will recognize and affirm.
Okay, well, thank you. Thank you so much for that. We've met before in these very same streets and courthouses. Jessica, West Coast Environmental Law and Raven, you know, intersect often. And one of our last cases was a Section 35 case around consultation. And that was with the Enbridge Northern Gateway Pipeline Project. Just what is a fundamental difference, like on the ground in cases like this, between, say, Section 35 rights, which are the duty to consult, and then this new sort of FPIC Dripa framework that brings in this notion of consent?
So I'd like to approach that through the lens of what's happening in this case, because I think it makes it more tangible. So just as a reminder to everyone, BC's mineral tenure regime goes back to the gold rush days and effectively allows anyone to go onto land, to stake it and acquire mineral rights without consultation or consent of Indigenous peoples. And the case surrounds a series of mineral claims that were made in Gitxaala territory on Banks Island in the heart of the territory without consultation and consent. And so if we think about these two sort of lenses on rights, Indigenous rights in the context of this case, one is the sort of story we know, right? So in 1982, Canadian Constitution, Section 35, recognizes and protects the existing Aboriginal and treaty rights of Aboriginal peoples. And so this is the case law that we've seen many times before the court. And it arose because BC and Canada effectively said, sure, there's constitutional protection of these existing rights, but we don't have to do anything. We don't have any obligations until you prove it in court or until you have a treaty, and then maybe even then, not so much. And so people have probably heard about the Haida and Tag River Tlingit cases going on now 20 years, where the court said no, if a government is contemplating conduct that could impact on asserted title and rights, even if they have not yet been recognized by the courts or by a treaty, there's a duty to consult and where necessary accommodate. So in other words, to talk with the nation with a genuine intention of addressing impacts on their rights and to make changes, to actually change what you're doing. So that's in a sense the story we know, the sort of body of case law we've seen many times as nations grapple with resource projects in their territory. And I will say first that in fact, this case, I believe, is winnable on those grounds, because it's very hard to argue that a system that allows someone to, pay $1.75 a hectare and with a click of a mouse acquire exclusive mineral rights in Gitxaala territory without any notification or consultation, very difficult to see how that is consistent with the Crown's constitutional duties, just based on well-established case law. That said, when we look ahead to the braiding together of Gitxaala and Canadian law that we're hoping to see, in other words, the evolution of British Columbia law in a way that respects and affirms and upholds Gitxaala law, that takes us into why the UN Declaration is so important in this case. Because in fact, the facts in this case are so bad. It's not like Gitxaala wants to be notified every time someone acquires exclusive mineral rights, or get a letter in the mail that says, tell us in 30 days what you think about this. Looking ahead to how we want the law to evolve, this is where Gitxaala's requested declarations in court that the mineral tenure regime is inconsistent with the UN Declaration, and that the Crown has an obligation to cooperate with Gitxaala and other nations to reform the law. And how will that make a difference? Many, many different ways, but let me mention three. So I mentioned the Crown's sort of prove it kind of approach. And in fact, that's the way the common law has evolved, that nations need to prove their title in court. And at that point, Canadian law says, sure, you need to get your consent, and if you don't consent, we have to come up with a justification. With the UN Declaration, we are talking about inherent rights that arise as a matter of nations' own deep connection to territory, their laws, their tenure systems, those inherent rights. In other words, we're starting from a place of rights recognition. Secondly, the need to be looking at the situation through an Indigenous perspective. The Crown in this case is saying giving away exclusive mineral rights in Gitxaala territory has no impact because there's no explosives, because the machinery isn't too big. There's no mechanized access. And Gitxaala is saying, no, there are profound impacts on our governance rights, our title, our law. And this is where taking that Indigenous perspective, as the UN Declaration would require, is very important. And finally, to re-emphasize what Conrad brought out, the standard set out in UNDRIP is that the Crown must consult and cooperate with Indigenous people through their own representative institutions in order to obtain their free, prior, and informed consent before giving away rights, mineral rights or logging rights, or approving projects in nations' territory. So that could be a profound game changer. On the facts of this case, the Crown doesn't even make the bare minimum legal standard, but as we look ahead to how we reform the law, that UN Declaration standard is going to be really significant.
Thank you so much. It's, you've been actually in court and listening to these arguments for the past week or so. Actually more, hey, it must feel a bit like a marathon. What are the kind of arguments that the government is retorting with? As as you sit there? What are some of their defenses? Because, under Dripa, this should already be common sense nearly, and certainly law.
Yeah. I have to say I found it profoundly disappointing and really saddening to hear the arguments that were brought forward. So I mentioned one of the fundamental pieces. The Attorney General's lawyer takes the position that giving away exclusive rights to minerals has no impact because of other consultation that they say will happen later. That as different, more and more invasive activities occur, each one will need a separate little permit. And then eventually there'll be an impact assessment and eventually a major mines permit. That argument was disposed of in the Haida case. In that case, we were talking about a logging tenure rather than a mining tenure. But in that case, that's exactly the argument BC made. They said, but we're going to consult on these cutting permits, on these operational permits down the line. And the court said, no, consultation needs to happen at the earliest stage. It needs to happen at the strategic level with respect to the granting of the resource. So it is an old argument, and it's quite astonishing to see the Crown bringing that forward, but that is their argument. They're saying, don't worry, we'll consult later. Have we drawn the line in the right place? We think it should come later. And that's just not what the Canadian courts have said. Their second major argument is that Dripa, the Declaration on the Rights of Indigenous Peoples Act, is not something that can be enforced in court. So they say if the Crown and Indigenous peoples disagree about whether a piece of legislation is consistent with the UN Declaration, really the only thing a nation can do is get it into that annual report to the legislature. The Crown argues that this is a political framework that's been established. It's not something that's justiciable. It's not something that can be enforced in court. And they say they took the judge to comments from the Supreme Court of Canada talking about how, we're all here to stay and we need, that reconciliation is about negotiation, neglecting to mention that since Indigenous peoples were able to retain lawyers again, which they weren't able to for a long time, it has been the resort to the courts that has in fact pushed the Crown to modify its behavior. And then I regret to say only reluctantly. And so I think that's not, once again, British Columbia is saying, trust us. We don't want the oversights of the court in terms of whether we measure up, whether our laws measure up to the UN Declaration. And I should say, if Gitxaala is successful, the Crown says, don't give them their relief right away. You should only give them a declaration. Like, don't give them anything tangible, like setting aside the claims or suspending the registry in the territory. Just give them a declaration that there was a duty to consult, and then suspend it. Give us some time. And I think that one of the Gitxaala legal team, my colleague Gavin, said, the Gitxaala has already been waiting a very long time.
This whole trust us, we'll do the right thing later kind of framework seems to be fundamental to this idea that, hey, negotiation is going to be the way forward. You won't have to litigate anymore. Let's stop all this pesky litigation and negotiate. And yet, I wish Matthew were here so I could ask how it really sounds from their perspective, but I'm going to bring that to you, James. I mean, it's a bit of a kind of poignant question. I mean, isn't this exactly what BC should have expected would happen, given that they opted out of the negotiation option on this one?
I had my cleverly push mute button. I'm good now. I had a lot of conversation to your first point about asking Matthew how he felt about this. I've been in court with them in the hearings with them, and I've had this conversation with them. And it disappointingly for me may have hit Jessica and myself a little bit harder than it hit them, and my hereditary and my leadership, because this is yet again just a continuation of the same kind of having their cake and eating it too policy development that these guys are so used to hearing and have heard for 50 years since the start of the Indian Act. Like, it's not, it may be my relative youth and inexperience that led me to be a little bit more disappointed in it. But that kind of expectation about, I think, the idea of kind of going to dispute resolution and going to these new processes that the Crown points to, I think if there was a substantial amount of effort put behind them from the Crown, dispute resolution, dealing with new ways of talking through these things, reconciling Indigenous law with their own process. I mean, Jessica talked a little bit about meshing the two, and Conrad talked about meshing two processes together. Had they put that kind of effort into it, I think the nation would have welcomed that. We've had conversations about wanting to welcome that kind of stuff before, but the problem we so often see is we get the term reconciliation as a process from them all the time. And the problem is that they want to control the process. There's no emphasis into coming to the nation and saying, what is a process that will work with you? And so I think for me, a lot of that disappointment was the opportunity seemed to be available to us. And my government, being a settler, didn't take advantage of it. And I think if they had, we might have had a better conversation. But like Jessica pointed out earlier, it's always down to the courts for these things, because unless they're forced to move, acting on those promises is such a long wait that you don't have these options. People can stake claims into 10 years that it will take us to work through some sort of process as it's dictated by them. So I don't know if that gets to the point you were going from, but it's definitely been conversations we've had.
Well, can we for a minute just zoom in to why the urgency? Why can't we wait? I mean, can we talk about what's been happening on Banks Island and what the nation has suffered environmentally, socially, culturally because of a dysfunctional mineral claim system and, of course, dysfunctional mining industry regulatory regime?
Of course, and certainly for those listening who don't know, there was an operating gold mine on Banks Island, which is kind of in the core of Gitxaala territory. They describe it often as their breadbasket. It's a huge. It's impossible in Gitxaala law to separate harvesting from spiritual practices, from cultural practices, from heritage. You have to think about them collectively. And Banks Island is a basket that holds all of that. And there was a mine that was operated without Gitxaala's approval through what I think is probably not the greatest consultation process, and then broke a number of conditions on its permits and has created quite the mess, polluting rivers, streams, wetlands, and stuff in the center of Banks Island, and remains uncleaned today as we still manage through the messy process that is the Crown's way of dealing with mines. And so that had our attention to mining. And there's also a problem we have of dealing more and more with translating out that law that Gitxaala has from a cumulative perspective. There's a Somalic word that means of one heart, and it means everything's connected. And we've been putting a lot of effort into dealing with translating that outwards. We're using cumulative effects assessments right now because that's a way that Western people kind of understand it. But that really drew our attention to how they can set up these dominoes of giving away mineral tenures and then consulting on a land use permit and then giving a Mines Act permit and then doing that. And if you tip the first one, they all kind of naturally fall over. And so that's what, looking at the consequence of that, drew us to the Mineral Tenure Act.
Okay. Yeah, thanks for the little glimpse of what it must have been like for the community to deal with all of
It-
that.
And still ongoing. Yeah, like it is still very live because it is still just a mess out there.
Sure. And, one part of the promise of this case is what it will do for other nations. There were so many different interveners, I think, because this case is so incredibly important and could be so impactful. I am wondering about this notion of precedent. So this would be the first time that Dripa is put to the test through the court. So I'm going to ask Jessica to just comment on, like, how would a precedent based on upholding Dripa advance Indigenous rights?
I think the first hurdle here is the invitation that's been made to the judge here to tell British Columbia that the commitments they made in Dripa, in the Declaration on the Rights of Indigenous Peoples Act, are something that the courts are going to supervise, that there is a recourse for nations as they cooperate and consult with BC as BC attempts to take all measures necessary to align their laws with the UN Declaration. So first and foremost, that is, I think, what this case will sort of stand for going forward. What remains to be seen is whether the court will need to go to the UN Declaration in order to give Gitxaala the relief that they need. So I spoke very briefly about how an automated system where the Crown concedes that they did not do any consultation before rights were granted ought to be a slam dunk under the regular Canadian common law tests. And so it remains to be seen whether the court will need to go to Dripa, to the UN Declaration as an interpretive tool. We are hoping that the court will say that, that the UN Declaration can be used to interpret all enactments as well as the common law, and that will open the door for future cases where, for example, it's a question of whether was consultation meaningful if it didn't get to free, prior, and informed consent. In this case, the facts are so egregious that it remains to be seen how far the court will need to go. But we do hope that we will establish that Dripa is justiciable, that that nations can go to the court, and that at a minimum, that the UN Declaration can be used and must be used as a result of changes to the Interpretation Act as a lens through which all enactments and the common law need to be looked at. And to make that a little bit more practical, what it would mean is if a statute can be interpreted in a way which is consistent with the UN Declaration and a way in which it is not, the new provisions of the Interpretation Act would tell us that the court ought to prefer the interpretation that's consistent with the UN Declaration. And so we will see how far the court needs to go to give Gitxaala the relief that they're seeking.
I wonder, one of the interveners was a mining company who are actually intervening in favor, essentially, of the nation's position, which was unique and cool. And in the press, I don't know if they brought this to the court or not, but in the press, they did talk about other jurisdictions, other countries like Australia and New Zealand, where FPIC is actually being applied. And part of what they were saying as a corporation was, we want certainty so that we can actually operate. And could you please hurry up and implement Dripa already? So did any of those conversations come in, or are you aware of places where there has been sort of a more successful application of FPIC outside of Canada? Just so we can start to think, well, what could this look like in the future? And anyone can jump in on this question.
I was maybe going to mention there were a number of jurisdictions mentioned in the various intervener submissions, including an expert report that Gitxaala had from a professor in Australia. But I actually wanted to mention in particular the IRMA standard, which is an international standard right now there is a mining standard and they have a draft exploration standard, which includes, for example, the standard of free, prior, and informed consent. And what's been happening is, these major companies, whether it's Tesla or Microsoft, I think Tiffany's, there's a number of them, and they're saying we want to be sourcing responsibly produced minerals, and that's where they went first. But then they're saying, but we want to know that that goes right back to the beginning at the exploration phase. And so that was something that First Tellurium, who is a member of that standards body, brought forward, is that this is becoming the international norm in terms of best practices. It's something that major purchasers of minerals are demanding. And so that was really helpful to have a company who was saying this is the getting consent, Indigenous consent, is an economic imperative. And that was a very important counterpoint to the sky will fall arguments we heard from the mining coalition.
Great to have that perspective, and it will certainly influence what's happening in the so-called Ring of Fire in Ontario as well. So while it's a BC specific, this particular look at Mineral Tenures Act, certainly in Ontario, they have a very similar claims regime that needs to be looked at as well. And of course, Indigenous peoples today just filed a challenge in the Ontario Supreme Court, taking on treaty rights and looking at not just mining, but sort of industrial development as a whole and its impacts on treaty rights in the so-called Ring of Fire, but a region known as a breathing land. So we're watching that attentively, as Raven is part of supporting that challenge as well. Okay, well, so much in a marathon of days. I'm wondering what's left to do. So we had thought that this would be over by now and wrapped up with a neat little bow, which, is only ever happens in theory. But in practice, you're in court for another few days, and I'm just wondering what's left to do, when it's over, and what we can maybe expect to find out, in terms of outcomes.
Yes, so in the proceeding has extended longer than we thought. There are 3 more days of hearing, May 3rd to 5th, and there are going to be several things happening. First of all, I did want to mention that the Hereditary First Nation has also brought a similar challenge that's being heard at the same time as Gitxaala. And one of the things that happened with them, and this sort of goes to what's still to come, the companies involved in their case kept on staking up minerals while the case was ongoing. And Hereditary learned this shortly before the first hearing dates, and they came to the court and said, listen, we need an interim injunction. This is crazy. People are staking claims while this is in court. So one of the things that will happen is that they've made that case to the court, and when we come back, British Columbia will be responding and explaining why they are resisting that interim injunction. So that's one thing that's happening. Secondly, one of the Crown lawyers unfortunately fell ill, and the portion that she was arguing was why giving away exclusive mineral rights to Gitxaala's minerals has no impact. We understand that she plans to take a day to explain that. So that will happen. And then most importantly, from our perspective, Gitxaala and Hereditary's legal teams will have the opportunity to reply to many of the arguments that were brought forward by the Crown before the case concludes. The decision in the interim injunction and Hereditary's application will probably get reasons on that first. You never know how long it's going to take to get a judgment from the court. It could be 6 to 8 months. We would sincerely hope, if Gitxaala is victorious here, that brings the British Columbia to the table, and that further appeals won't be necessary, but that is always a potential.
We have a number of questions from people who have emailed in and also people in the chat. So this is one that we get all the time, and I'm curious about this too. And maybe it's a bit of a tongue-in-cheek trickster question, but I always think of the yes men who sort of pull these pranks in order to shine light on injustice. Why don't nations just stake claims themselves, or have activist groups stake claims to make a point or even to protect land?
I can start, Jessica, and I'm sure you can pick some up. While it's relatively cheap per hectare, territories are huge. And so first of all, there's a cost of doing that and renewing them every year, which is always just an easy thing to think about. More importantly for Gitxaala it's the nation's land. We shouldn't have to buy back the mineral rights and then keep them going based on funding that we can find or helpful ally groups that want to participate. The overarching impact on someone like Hiwaas's own territory is that the mineral rights are being given away. And so even if we can give those rights away to the band or an NGO group or something like that, they're still inherently being given away. And it doesn't get to the root impact to Hiwaas's governance, to the nation's laws, and it doesn't address the root problem. And so while it may be a Band-Aid solution, and it may have been a Band-Aid solution that was appealing even a couple of years ago, the ability to get the recognition of the inherent injustice of the law, I think is the key. And I Jessica, I don't know if you have anything to add.
No, that's well said.
Sure. Yeah. Why use the master's tools when they're fundamentally working at odds against your very own frameworks that you're trying to revitalize? Yeah. Well, thank you for that. We are circling back. People really want to know about how First Nations have taken control of mineral resources from settler governments.
I had just put in the chat a link to a really excellent resource from the First Nations Energy and Mining Council that speaks to the consent standard. It looks at it throughout the cycle of the mining sector and draws on a number of expert reports and examples that kind of speak to that. I mean, one of the ways that I would approach that is, obviously, mineral rights are part of a broader bundle of rights and relationships that form part of the inherent title that nations have. And so one of the key ways that nations have been sort of wrestling control is, for example, through the declaration of Indigenous protected and conserved areas. So if you think of Will Politz, which is a Gitxaala house, who, because of climate change, has seen shifts in where the most significant salmon habitat is, and really wanted to protect that. When BC was saying, no, we can't expand protection because of these mineral claims, they said, okay, that's enough. We're going to declare this as an IPCA. A number of other nations, Lower Similkameen, Casca, Taika River Tlingit, are all saying, in a sense, that's part of what they're doing, and so in some cases, those declarations also involve sending notices to vacate to mineral claim holders, but not just them, but to potentially, big logging companies or tourism lodges that were built without their consent. And so I guess just sort of flagging that from that holistic perspective, that's one of the leading examples in BC right now of how nations are wrestling control over their territories and acting on their own laws and jurisdiction.
I think I can add to, the inverse of that is also really interesting to me too, and that in some cases, and this speaks to, Andrea, what you were talking about earlier about the intervener mineral tenures who put the mineral exploration companies who put FPIC front and center in their own work. There are companies who have partnered with the nations and will have agreements that they will walk away if they can't get consent, and they are working with those nations on individual, so like postage stamp size projects. And for me, that gets to kind of the disappointment in the province and the tenures, is that they're relying on one or two good actors for good stories, and they're not leading the way. In almost everything I do, it's the nations and then industry, and then bringing up the rear is always the crown. And it's disappointing to see that they haven't tried to jump ahead of industry, but we're still seeing a lot of like good acting industry who have an economic benefit in mind, knowing that they should be partnering with nations because they've seen the way that the tides are turning. And so you're seeing both them wrestle stuff away from the government, like Jessica was talking about, and then you've also seen a recognition of that control being exercised by kind of a regulatory agreement with proponents. And so I think that's really interesting to watch together. Again, disappointing that the province isn't doing anything about it and just letting it happen. But I'd like to see them take more of a leadership role, but they're not.
Well, and they're also spending our money, taxpayer money, to fight nations like Gitxaala in court. I am going to take this opportunity to turn to you, Conrad, and just ask you, what is it costing nations to actually get BC to do the right thing? Like, people have this notion that First Nations are somehow propped up or have special status, but in fact, they need to raise the money and spend their money from their own coffers in order to defend their rights in court. Can you talk a little bit about that imbalance and maybe where Raven comes in the Gitxaala case?
Yeah, so I think that's a great question. As you alluded to, well, as most people might be aware, most First Nations administration, aka their band offices, really are in a capacity scarcity, whether that be through professional people with credentials like lawyers and accountants, or whether it be with different levels of capacity like financial abilities to afford to litigate. And I think, speaking a little more about what James is talking about, and I think what kind of connects with what you're talking about, is that there are a variety of substance and rights at play with all these intersecting kind of, legislative accords and common law within Canada, as Jessica was talking about, like 100 years of court decisions under the common law. And so I think the challenge is that most First Nations cannot afford to litigate to assert their rights. I think that almost goes without saying. And I think that the ones that do are finding themselves in very similar situations as the Gitxaala. You're raising the concerns of potential infringements on the variety, I guess, or substance of rights, and the degrees to which those rights are affected, and whether or not they create an abrogation or derogation, as UNDRIP tries to avoid or tries to harmonize as we go forward in the evolution of Canadian jurisprudence.
Thanks very much for that. Yeah, so when I think about fairness, which is a sort of very lay term, but it's very fundamental to us as human beings. The fact that Gitxaala are doing such heavy lifting, certainly on behalf of future generations and on behalf of their own people now, but also like to benefit everyone in British Columbia, to benefit all future generations, and to benefit other First Nations. It's really inspiring to see the amount of support that people have stepped up with. And, that's everything from supporting them at the courthouse and attending every day. They've had really, really great media support as well. I think as well, the fact that people have donated and there's been this pool of donors to triple funds has really, really been inspiring. So just since the beginning of the court hearing, $100,000 has been raised for the legal challenge, which when you look at the number of expert reports and arguments that have been put together and the legal teams that are working and interveners as well, it's a huge amount of resources that needs to be mustered to make this happen. And it really is occurring because people are joining forces. I think because people see the sense in supporting First Nations just kind of inherently, because it is kind of already a tilted playing field. But I think also we all have our eyes on the prize, which is a new way forward. And unfortunately, it is up to ordinary people joining hands and putting the resources together to support people like Jessica and James and the interveners in a case like this. So at this point, I just want to let folks know who maybe haven't had an opportunity to contribute that they can. So you can give through raventrust.com/Gitxaala, and I'll put that in the chat in just a moment. Know too that Raven has an intervener fund. So essentially, I'm going to also turn to you, Conrad, and ask you to just explain what intervention is for those of us who are not lawyers, and just talk a little bit about what impact that can also have.
Yeah, well, the interveners, of course, present a question to the courts on whether or not they have potential, again, going back to the substance and variety of rights, and whether or not the weighting is kind of equalized in the question of law at hand. And so the interveners, like we've had the Gitxaala hereditary chiefs through Raven, specifically for Gitxaala, the chief of Sequoiax, Newhulk, Chief Alien Prince from Codsley Wooten. We spoke about earlier about the mining spokesperson, I believe it's Jacinda, and also, Jamie Neen with Mining Watch Canada as an intervener. And when you think of people like Mining Watch stepping up to the plate to assist in, I guess, the public sentiment around the issue at hand, as Gitxaala litigates and presents an opportunity for the province to respect, I guess, free, prior, and informed consent, speaks to the nuance, I guess, that James was alluding to earlier, of how some people are just going ahead and taking the lead on different, I guess, variations on how to implement these in the name of reconciliation. And also there's the Chief Terry Tagee from the BC Assembly of First Nations, asking how the political commitments regarding the Mineral Tenure Act in this era of the Declaration on the Rights of Indigenous People, he feels is unacceptable. And it's so inviting these different peoples, I guess, at different various levels of leadership, including the provincial and federal government, to try and find solutions as we go forward.
Okay, well, we just have 5 minutes left. I'm wondering if there's any more kind of burning comments that folks want to leave us with as we move forward. I just can't help wanting to acknowledge that what's happening at the Supreme Court of BC in these next few days is just so incredibly consequential to all of our future. And we're so grateful to you, Jessica and James, for the work that you've been doing. It's sort of this culmination of so much work and so much time in these very short and intense days. And I hope that someone's feeding you hearty breakfasts and healthy dinners at the beginning and end of each of these days. Yeah, it's hard to kind of encapsulate the significance of moments like this, because of course, once the court hearing ends, we just get silence. We just don't know what the outcome's going to be for months and months. So maybe just share a little bit about how you're feeling about how it's gone, and your sort of sense of your outlook on the future of this.
It has been both incredibly heartbreaking to hear this kind of stuff, and it's been incredibly meaningful for me and for the nation to have a chance to come together again, to have a chance to put forward Gitxaala law. I mean, one of the things that happened in the nation was that their own legal processes around bringing this case forward. And so part of doing that is already in filing the case and bringing these arguments forward. We're upholding Gitxaala law for Gitxaala people, and we're helping them as a group of non-Gitxaala members who are shoring them up to make good on their own law, to help realize their own legal practices. And that's been incredibly amazing. And to see that kind of manifest in it being discussed in the courts and it coming through all the different legal stuff. And we talked about interveners, to hear the words from other interveners, to hear the arguments and the support and the kind of violence and harm that's being done to other nations that are bringing forward, and to give it a space to be heard, I think is really important. And that's been really good. I mean, I will remember the words of the BC Human Rights Commissioner in their presentation about meshing to legal things for the rest of my life. So those opportunities have been amazing, but it's bittersweet, because as the First Nation Summit representative has said numerous times, we shouldn't be here. We shouldn't need this venue to have those experiences. And so I'm very much grappling with that. And I think the nation is looking forward to a positive resolution on this. I think they're confident in the kind of stuff Jessica talked about earlier. But we also know that even with that kind of declaration, we're not at the end of anything. There's still work to be done, regardless of what the decision is. And so I'm always amazed at the ability of my leadership and my hereditary to dig in after generations of colonization to look at the next step that they have to take. And so that to me is kind of where I'm sort of wrapping up my thoughts around this right now.
That's really that's sort of where my heart was as well, James. You know, when I picture the chiefs and the matriarchs walking into that courtroom and sitting there together, bearing witness on what was happening, they're living their law. They're holding up the responsibilities they have and the relationships they have with their territories, with their ancestors, you know, with the children to come. And they reminded us when we were feeling angry, when we were feeling sad, outraged, that responsibility continues, and they will continue to live and uphold their law, and that will prevail. And I think that was, I have the honor of working with knowledge holders and elders and leadership who've taught me many, many things. But I felt that resolve, and I felt that how profound their knowledge and their connection to their own laws and their own place. And that is really what's at the root of this case. And I know our colleagues at Angaris Fong and other lawyers at West Coast who are working on it. I know that we all felt that very profoundly.
Well, thank you for giving us a little taste of that. We're just, on behalf of the Raven community, we're hugely thankful to you, Jessica, and to your team at West Coast Environmental Law. And James, to you and to the community at Gitxaala, it's an honor to be able to say thank you for taking this on in such a powerful and good and sustained way. Just tireless commitment, and we really see, Indigenous law in action. It's a beautiful thing to behold. Also thanking Conrad and Levin Chamberlain from Raven for creating a container for the support of Raven donors to land. And to all of you who are listening and who are maybe watching this video afterwards, your support is so important and so appreciated. It makes this work possible, and it gives us all the stamina to keep going when sometimes these challenges take a long time and there are many appeals and so on. It really, really matters that you hold the sort of kernel of vision of what can be accomplished here and of who you're supporting. So thanks again, everyone, for making the time in the midst of a very busy moment. And we really, really appreciate the transmission of wisdom and knowledge tonight. So with that, I will say good evening and see you next time. Thank you so much.
Thank you all.
Thank you.
Thank you.